यूएनडीपी, यूनिसेफ, इंटरनेशनल लीगल फाउंडेशन के सहयोग से फर्स्ट रीजनल कॉन्फ्रेंस ऑन एक्सेस टू लीगल एड, स्ट्रेंथनिंग एक्सेस टू जस्टिस इन ग्लोबल साउथ का सफल आयोजन किया है। मैं इस अवसर पर उच्चतम न्यायालय के 4 जो जस्टिस दलबीर भंडारी, जस्टिस आर.एस. पाठक, जस्टिस नागेंद्र सिंह, जस्टिस सर बेनेगल राव, जो इंटरनल कोर्ट ऑफ जस्टिस में जज के रूप में अपनी सेवाएं दे चुके हैं, जो कि विश्व में भारतीय न्यायपालिका की स्वच्छ, निष्पक्षता और प्रभावशाली छवि का परिचायक है। एक तरफ भारत विश्व की 5वीं सबसे बड़ी अर्थव्यवस्था के रूप में तेजी से विकास यात्रा पर गतिमान है, वहीं दूसरी ओर अल्टरनेटिव डिस्प्यूट रिजोल्यूशन के माध्यम से कानूनी मध्यस्थता का हब बनने भारत जा रहा है। मैं इस अवसर पर कानून और न्याय मंत्रालय ने जो विजन 2047 के रूप में जस्टिस फॉर ऑल का लक्ष्य प्रस्तावित किया है, इसके अंतर्गत स्पीडी, अफोर्डेबल एंड टेक्नोलॉजी इनेबल्ड सिटीजन सेंटरिंग डोर स्टेप जस्टिस डिलीवरी सिस्टम के द्वारा न्याय की सुगम पहुंच का लक्ष्य रखा गया है। आज अमृतकाल के अंदर आत्मविश्वास से परिपूर्ण भारत देश आत्मनिर्भर होकर 2047 तक विकसित होने के लक्ष्य पर आगे बढ़ रहा है। इस लक्ष्य की प्राप्ति के लिए एक मजबूत, निष्पक्ष एवं स्वतंत्र न्यायिक व्यवस्था के आधार स्तंभ के रूप में सुप्रीम कोर्ट महत्वपूर्ण भूमिका निभाएगा। न्याय का मंदिर बना रहे सर्वोच्च न्यायालय हमारा, न्याय का मंदिर बना रहे सर्वोच्च न्यायालय हमारा, संविधान का रक्षक बना रहे सर्वोच्च न्यायालय हमारा। आज अमृत वर्ष की बस यही शुभकामना है, देश का गौरव बना रहे सर्वोच्च न्यायालय हमारा। बहुत बहुत धन्यवाद।
धन्यवाद माननीय मंत्री जी। May I now request the Chief Justice of India, Justice D.Y. Chandrachud, to please share his thoughts with us on this momentous occasion.
Honorable Prime Minister of India, Shri Narendra Modi ji, my colleague judges of the Supreme Court of India, Chief Justice Obaidul Hassan, Chief Justice of Bangladesh, Justice Kinley Dorji, Judge Supreme Court of Bhutan, Chief Justice Bibi Rehana Mungli Gulbul, Chief Justice of Mauritius, Chief Justice Bishwambar Prasad Shrestha, Chief Justice of Nepal, Chief Justice Jayant Jayasuriya, Chief Justice of Sri Lanka, Chief Justices and Judges of the High Courts, former Chief Justices of India and Judges of the Supreme Court of India, Mr. R. Venkatramani, Attorney General for India, Mr. Tushar Mehta, Solicitor General of India, Mr. Manan Kumar Mishra, Chairman of the Bar Council of India, Dr. Adish C. Agarwal, President and Executive Committee of the Supreme Court Bar Association, President and members of the Supreme Court Advocates on Record Association, Vice Chancellors of the National Law and other universities, members of the Bar, students, young and not so young, you're all students for our whole life, distinguished guests, ladies and gentlemen. Today is a momentous occasion in the history of our nation. The Supreme Court of India marks the commencement of the Diamond Jubilee year of the moment of its inception on 28 January 1950. First and foremost, I thank the Honorable Prime Minister of India, who graciously agreed to be with us, address the audience, and launch the new initiatives of the Supreme Court of India. I also extend my heartfelt gratitude to my esteemed counterparts from Bangladesh, Bhutan, Mauritius, Nepal, and Sri Lanka for joining us in commemorating this occasion together. India has long-standing cultural bonds with them, and the presence of the Chief Justices today strengthens India's ties with their nations. A conversation about this court must necessarily be prefaced with a conversation about the Constitution of India. It was through the Constitution that the people of our country gave to themselves this court. The Constitution is not just a legal document. Its soul lies in the feeling which it engenders, a feeling of mutual respect towards fellow citizens, a feeling of responsibility in the institutions which it creates. The constitutional ideals permeate the fabric of our nation, guiding the actions and interactions of both the governed and those who govern them. The Supreme Court was established with a sense of idealism that laws would be interpreted by a constitutional court in accordance with the rule of law and not by colonial values or social hierarchies. It affirmed the belief that the judiciary should serve as a bulwark against injustice, tyranny, and arbitrariness. The Supreme Court is an institution of resolution and justice. The fact that people approach it in large numbers speaks to how far we have succeeded in discharging that role. Today is not only a celebration of that one day when the Supreme Court came into being. It also is a celebration of the decades' worth of hard work by succeeding generations of judges and lawyers that went into making this a people's court. In celebrating the history of this day, we must look back and look forward in equal measure. Since the founding of the court, our actions have been guided by Mahatma Gandhi's profound words. Recall the face of the poorest and weakest man whom you have seen, and ask yourself if the step you contemplate is going to be of any use to him. Our decisions, both in the judicial and administrative realms, have been aimed at enhancing accessibility to the Indian judicial system for common citizens. Through its judgments, the Supreme Court has enhanced the rights of citizens by diluting the standards of local standi and by recognizing a new set of rights under Article 21 of the Constitution, such as the right to a speedy trial. On the administrative side, the Supreme Court has been identifying and eliminating as many barriers to justice: unequal access to legal resources, unfamiliarity of the English language, issues of physical accessibility of courts, in order to create procedural fairness. The e-courts project of the Supreme Court of India attempts to enhance accessibility and transparency of the justice delivery system. At the heart of these initiatives is the desire to transform the judicial system into a technology-enabled, efficient, accessible, and environmental-friendly institution. Let me briefly summarize the achievements of the court in simplifying its process. E-filing of cases. The front desk experience of approaching courts has changed completely. As opposed to lawyers lugging trolley carts of papers, we now have the facility of filing cases at the click of a button. An upgraded version of the Supreme Court's e-filing platform was launched in May 2023. It offers a host of improved features that have made 24/7 filing of cases simpler, faster, and convenient. Nearly 128,000 e-filings have been done so far, with a consistent rise in the share of e-filings compared to physical filings. E-filings are available in 25 states. They have recorded over 29 lakh cases which have been e-filed. With the immense support of the bar and the bench, we were able to swiftly shift to virtual hearings during COVID-19. Even after the pandemic, hybrid hearings continue to be a feature of our courts. That is, any Indian lawyer sitting in any part of the country or the world can argue before this court through video conferencing. This has democratized access to the Supreme Court. It has opened the space for those who are unable to approach the Supreme Court due to physical distance or want of resources. Even yesterday, one of my colleagues joined the bench through video conferencing for a special hearing on a Saturday. Till now, we have dealt with over 5 lakh cases through hybrid hearings. The live proceedings of the Supreme Court Constitutional Bench hearings are popular and speak to the genuine curiosity that people have towards our courts and procedures. Focus on scanning and digitization. The Supreme Court of India today operates in a near complete paperless mode, with almost all benches using digitized paper books. Judges are provided with scanned, bookmarked, and digitally signed case records, which they access, read, annotate, and preserve for their reference at their residences and in courtrooms. More than 13 lakh legacy and live case records with approximately 10 crore pages, have been digitized. Futuristic courts. The Supreme Court has enabled futuristic court technology in 3 courtrooms, and soon other courtrooms shall be equipped with such technology. This technology facilitates paperless proceedings, a comprehensive digital library for the bench and the advocates, state-of-the-art video conferencing, large video walls, smart monitors, and document visualizers, all of which redefine the courtroom experience. Office automation. Adoption of e-office has enabled the officers of the Supreme Court Registry to perform their routine works in a paperless mode. 36 branches of the Supreme Court's registry have been onboarded on e-office, and more than 4,000 office files have been processed online so far. Suswagatam. Launch of the Suswagatam portal has enabled visitors to generate entry passes online in a paperless mode. A total of 1,23,000 entry passes have been generated so far using Suswagatam. We are also transcribing oral arguments in matters before constitution benches, which can be accessed on the Supreme Court website. The Supreme Court has entered into an MOU with IIT Madras to explore areas that can be completely automated and to leverage technology and artificial intelligence for enhancing process efficiency. As we speak today, a team of generative AI researchers at a premier management institute in Mumbai has built an end-to-end demo of an actual open-source Gen AI model trained in public domain motor accident cases. It is trained to automatically extract parameters from petitions, documents and files, and give a recommended compensation figure. Together, e-filing, digitization, paperless courts, and e-office constitute the golden quadrangle of transformation within whose enabling perimeter the Supreme Court of India is set to uplift the experience of everyone who is either a part of the judicial system or who comes into contact with it. But what is the future? The Supreme Court is soon going to migrate its digital data to a safe, secure, and sovereign cloud-based infrastructure. This would be a shot in the arm for the IT setup of the court. Cloud storage would ensure privacy, integrity, high availability, and secure accessibility of the Supreme Court's domain data. We are also on the verge of opening a war room equipped with technology that would enable the Supreme Court to monitor judicial data of the entire country in real time by using the National Judicial Data Grid and iJuris, both of which were information sharing platforms. For the district judiciary, iJuris has been launched by the Supreme Court to monitor statistics of vacancies and infrastructure relating to the district judiciary. Facilitating free accessibility of judgments for citizens and litigants has always been a priority of the e-courts project. As of today, 36,209 judgments are uploaded online on the ESCR portal in English, out of which about 36,000 judgments have been translated into Hindi, and around 11,000 judgments have been translated to other Indian languages with the help of AI-assisted machine learning. The Virtual Courts initiative has been a game changer in courtroom access and online dispute resolution. Implemented in 20 states, the initiative has received 4.37 crore challans, leading to a total collection of 502 crores of rupees in fines. Interestingly, according to the Electronic Transaction Analyzer of the Government of India, in 2018, e-courts had surpassed even the Indian Railways in terms of total electronic transactions. All 713 district courts' websites have been migrated to the S3VAS framework of the National Informatics Center, which offers a user-friendly interface, greater customization, and compliance with the guidelines for Indian government websites, thereby ensuring better accessibility for differently abled users. On the National Judicial Data Grid, a repository of nationwide judicial data, information on 3,256 countrywide courts, the High Courts, and the Supreme Court of India is now a click away. Just as we make our courts tech-savvy, we must also realize that India is going through a period of social and demographic transformation. Anyone who visits India will notice a striking feature of the changing demographics of the nation. Now, women can be seen in important positions across India, whether it be in the operation theaters, the borders of the nation, in the high skies as fighter pilots, in the seas as naval commanding officers, all across the country and of course in the Supreme Court. There is a focus on greater inclusion of the marginalized sections of society. Equally inspiring is the confidence of the younger population to succeed in their professional lives. Traditionally, the legal profession was a profession of elite men. Times have changed. Women traditionally underrepresented in the profession now constitute 36.3% of the working strength of the district judiciary. In the recruitment examinations for junior civil judges conducted in several states, namely Andhra Pradesh, Arunachal Pradesh, Chhattisgarh, Delhi, Himachal Pradesh, Karnataka, Madhya Pradesh, Maharashtra, Odisha, Rajasthan, Sikkim, Uttar Pradesh and Uttarakhand, more than 50% of the selected candidates were women recently. In the Supreme Court of India, we hire law clerks cum research associates to assist the judges, out of which 41% candidates are women this year. We as judges and administrations cannot be ignorant of these rising aspirations. Before the beginning of 2024, only 12 women were designated as senior advocates in the history of the Supreme Court over the last 74 years. Last week, the Supreme Court designated 11 women coming from different parts of the country as senior advocates in one selection. Our legitimacy will endure from the inclusion of diverse sections of the population in our system. Therefore, we need to make more efforts to bring different sections of society into the legal profession. For instance, the representation of scheduled castes and scheduled tribes is quite low, both at the bar as well as on the bench. In the near future, we must address the structural issues affecting the judiciary, such as the pendency of cases, our archaic procedures, and the culture of adjournments. Our effort in our work as judges and administrators must be to ensure dignity to the district judiciary, which is the first point of contact for our citizens. Our ability to remain relevant as an institution requires us to recognize challenges and begin difficult conversations. And I'll highlight 4 issues as I conclude on difficult conversations. First, we must emerge out of the adjournment culture to a culture of professionalism in our courts. Second, we have to ensure that the length of oral arguments does not interminably delay judicial outcomes and lead to the capture of judicial institutions by the powerful and the mighty. Third, the legal profession must provide a level playing field for first-generation lawyers, men, women, and others from marginalized segments who have the will to work hard and the potential to succeed. And fourth, let us begin the conversation on long vacations and decide, of course in consultation with the bar, whether alternatives such as flexi time for lawyers and judges is possible. The 75th year since the founding provides an opportunity to meet these challenges and step into the future with an honest assessment of our progress. We must reflect on the journey that we have traversed and renew our pledge to uphold the Constitution within and beyond our courtrooms. Our mission to make the judiciary accessible to all would be incomplete without the support of our high courts. I thank the judges and the staff of all the high courts, as indeed I thank my own colleagues and staff in the Supreme Court in facilitating our initiatives which are being launched today. Thank you. Namaskar.
Thank you so much, sir, for this insightful and eloquent address. Your words will continue to resonate with each one of us present here for all times to come. When the winds of change blow, some people and institutions build walls, while the others build windmills. Taking note of the winds of technological progress and change blowing across the world, the judges and the administration of the Honorable Supreme Court of India decided to embrace and harness the transformative power of technology to enhance accessibility, efficiency, and transparency within the judicial system. As the Supreme Court of India enters a brave new world of technological advancement, it continues to make incredible strides in its institutional journey. Today, we shall witness the launch of 3 citizen-centric e-initiatives of the Supreme Court of India, such as the Digital Supreme Court Reports, DigiSCR, the Digital Courts 2.0, and the new website of the Supreme Court of India. अब मैं माननीय प्रधानमंत्री जी से निवेदन करती हूँ कि वो अपने समक्ष रखे हुए रिमोट का बटन दबाकर इन इनिशिएटिव्स का औपचारिक रूप से लोकार्पण करें।
The Supreme Court of India has consistently striven to assimilate tools of technology in its core operations to enhance access to justice and improve administration of justice. Supported by National Informatics Center of the Ministry of Electronics and Information Technology, Government of India in this endeavor. The court has launched a series of citizen-centric services with the aid of IT. On the historic Diamond Jubilee celebrations, the Supreme Court adds 3 more initiatives to its repertoire of e-services. DSCR marks the commitment of Supreme Court of India to make its judgments available to citizens, especially law students and young lawyers, free of